About another topic that was a favorite of Justice Scalia, one that I came to respect personally. Now, when you're a practicing lawyer, or even when you're a judge, people talk about legislative history as if it is somehow a mystical and magical thing that will provide the answers to all questions. But Justice Scalia was pretty much critical of the use of legislative history, or I should say the misuse of legislative history, where statutes were ambiguous. Matter of fact, my able staff has pointed out one story that he apparently invoked in a 1993 case. You may be familiar with this. He said the use of legislative history is the equivalent of entering a crowded cocktail party and looking over the heads of your guests for your friends. So when judges use legislative history basically to find a way to confirm maybe even their own bias or to confirm their outcome in a case, I think Justice Scalia is telling us that that's dangerous territory, and you ought to enter it with caution. So I'd like to have you comment on it, but there was a dissent he wrote in another famous case, Hamden versus Rumsfeld, where he said legislative history to justify the court's opinion. He said the question, talking about the question in the case, was divisive, and floor statements made on both sides were undoubtedly opportunistic and crafted solely for use in the briefs in this very litigation. He went on to say the handful of court statements that the court treats as authoritative do not reflect any general agreement. They reflect a now common tactic, which the court once again rewards by pursuing through floor speech ipsa dixit what could not be achieved through the constitutionally prescribed method of putting language into a bill that a majority of both houses vote for and the president signs. Before you respond, Judge, I just want to mention one other anecdote. Since I've been here in the Senate, I've actually been on the floor of the United States Senate where we vote to pass legislation, and then a senator comes out and says, and now for some legislative history. I was shocked. But with the loose way that courts sometimes treat legislative history, that, as Justice Scalia said, can reward bad behavior on the part of the legislature. So would you now offer us your views on the appropriate use of legislative history and how judges should review legislation passed by Congress where there is some perceived ambiguity?
I'd be very happy to, Senator. Excuse me. I'd start by saying that a good judge entertains all arguments from all comers. So you read the briefs as presented to you. You don't tell people what they can and can't argue, generally speaking. There are more and less persuasive arguments to be made, but people get to make their arguments. I believe in trial lawyers, for example, getting to try their cases, and appellate lawyers getting to argue their arguments and leaving them space and the courtesy of room to do that. So I don't believe it's my job to tell people how to argue their own cases. Presumptuous of the judge. I would say that it's well known, and I think appropriately so, that the law that governs is what this body passes in connection with the House of Representatives and signed by the president. That's the law. That's all that's the law. That's the law. Nothing more and nothing less. And everything else stitched around it is not law. And it may or may not have persuasive value in interpreting and understanding the law. But it isn't law. The founders in the Constitution prescribed a process for making law. And they made it hard. They made it really hard. That was the part of separation of powers. They really believed in it. They didn't want lawmaking to be easy because they wanted to preserve the liberty of the people. So they divided the lawmaking authority between two bodies. And they required the signature of the president or a legislative override. Tough process. Not the case in every country in the world, or even in every state. So that's what law is. And there are some due process considerations in this area, fair notice considerations in this area that I take seriously. That we charge people with notice of the law, right? Generally speaking, ignorance of the law is no excuse. We assume that it is reasonable for the people to be on notice of all 5,000 federal criminal laws that this body has passed. Is it also reasonable to expect them to know all the floor statements that have been issued about the law? Everything that might have been entered into the record but not discussed by unanimous consent? Is that reasonable? Is that fair notice? Is that due process? And these aren't idle considerations, because more often than not, we're talking about a criminal statute. And we're talking about whether someone goes to prison for a long time. And I have concerns about relying on things that are not law and charging people with notice of things that are not law as a basis for putting them in federal prison. That's the concern. So I hope I've addressed your question, Senator.